Good morning, friends. Today I will discuss judgment of our Honorable Supreme Court, which has granted bail to an accused despite the rigors of Section 37 of the NDPS Substance Act 1985. In a path-breaking judgment on bail jurisprudence, the Honorable Supreme Court has held that undue delay in trial can be ground to grant bail to an accused despite the rigors of Section 37 of the Narcotic Drug and Psychotropic Substance Act 1985. Divisional Bench of Honorable Justice S. Ravindra Bhatt and Dipankar Datta, while granting bail to an under trial prisoner arrested 7 years ago for allegedly being part of the ganja supplying gang, held grant of bail on grounds of undue delay in trials cannot be said to be fettered by Section 37 of the Act. Given the imperative of Section 436A, which is applicable to offences under the NDPS Act 2, the court also held that only prima facie consideration is required under Section of NDPS Act. And as a plain reading and literal interpretation of the conditions under Section 37 would effectively exclude grant of bail altogether. Now, as per Section 37 of the NDPC Act, the court can grant bail to the accused only if it is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. This appeal has arisen out of a case involving the supply of ganja, in which four of the appellants accused were found to be in possession of more than 100 kilograms of prohibited substance, and the appellant, that is Muhammad Muslim, was subsequently implicated on the basis of confession statements of one of the accused. The court also noted that the appellant was only 23 years old at the time of his arrest. The matter traveled in appeal to the top court after the Delhi High Court rejected his application for regular bail. Section 37 NDPS Act only requires prima facie determination. In the judgment authored by our respected Honorable Justice Bhatt, the bench explained that while the right of an accused to be granted bail was circumscribed by the legal exceptions contained in special acts such as NDPS Act, the standard to be considered even within the context of Section 37 of the Act would be that of prima facie determination. The court would look at the material in a broad manner and reasonably see whether the accused guilt may be proved. The judgments of this court have emphasized that the satisfaction which the courts are expected to record, that is, the accused may not be guilty, is only prima facie, based on a reasonable reading which does not call for meticulous examination of the material collected during investigation. Plain and literal interpretation of Section 37 and DPS Act will effectively exclude the grant of bail. The bench noted that in earlier judgments, such conditions had generally been upheld on the ground that the liberty of such accused as citizen of the country be balanced against the public interest. The bench acknowledged that a plain and literal interpretation of the conditions under Section 37, requiring the courts to be satisfied that the accused is not guilty and would not commit any offense would effectively exclude grant of bail altogether, resulting in punishment, detention, and unsanctioned preventive detention as well, the bench categorically stated. Therefore, the only manner in which such special conditions as enacted under Section 37 can be considered within constitutional parameters where the court is reasonably satisfied on the prima facie look at the material on record that the accused is not guilty. Any other interpretation would result in complete denial of the bail to the person accused of offences such as those enacted under Section 37 of the NDPS Act. Stringent bail conditions were enacted on the condition that trial will be expedited. The court noted that Section 37 NDPS Act and other similar provisions with such stringent conditions for bail, such as Section 43D of UAPA, Section 45 of the PMLA, have been upheld. When these strong provisions are enacted, curtailing the provisions of the bail and restricting judicial discretion, it is on the basis that investigation and trial would be concluded swiftly. The court noted in this regard after referring to precedents. Reference was also made to the decision in Union of India versus Najib, where it was held that the hard conditions under UAPA will not fetter the right of constitutional courts to grant bail on the ground of violation of fundamental rights. The judgments also refer to precedents which hold that right to speedy trial is a fundamental right. Court refer to statistics on under trial prisoners. Before concluding, the bench refer to some important figure revealed in response to above by the Union Home Ministry on the floor of the House. The National Crime Record Bureau had recorded that as on 31st December 2021, over 5,54,034 prisoners were lodged in jail against the total capacity of 4,25,069 lakhs in the country. Of these, 1,22,852 were convicts and rest 4,27,165 were under trial. The court further added that laws which impose serious conditions for grant of bail may be necessary in public interest. Yet, if trials are not concluded in time, the injustice wreaked on the individual is immeasurable. Jails are crowded and their living conditions more often than not appalling. The danger of unjust imprisonment is that inmates are at risk of prisonization. There is further danger of the prisoner turning to crime. As the crime not only turns admirable, but the more professional the crime, the more honor is paid to the criminal, the court held. It was also noted that incarnation has further deleterious effects. Where the accused belongs to a weakest economic strata, immediate loss of livelihood, and in several cases, scattering of families as well as loss of family bonds and alienation from society. Having explained this, the bench concluded by saying the courts therefore have to be sensitive to these aspects because in the event of an acquittal, the loss to the accused is irreparable and ensure that trials, especially in cases where special laws enact stringent provisions, are taken up and concluded speedily. I have taken this material to be very frank from our case title, that is Muhammad Muslim versus State NCT of Delhi, and under specially petition criminal number 915 of 2023. Citation is 2023 Lebla SC 260. So, no doubt, the section 37 is very stringent provision of the NDPS Act 1985, but it comes with the duty of speedy trial. If we are not in this infrastructure able to complete the trial within time, then we should have to think about the legal rights of the accused too. So what that our honorable court has given justice to that accused who was in jail for so many years. Thanks for listening. God bless you all. This is all about